everyone, and welcome to the daily newspaper analysis, which is brought to you by LawSikho. So today we have an editorial that we have taken from the Hindu newspaper. The title of this editorial is "A Dismissed Review Petition, an Egregious Error." This actually talks about the recent happenings that have taken place in the Bilkis Bano gang rape case. So we'll proceed with that in today's discussion. Then we have news update and legal news for the day. So on December 13th, 2022, that is very, very recently, the Supreme Court issued a 2-page order wherein the review petition that had been filed by Bilkis Bano against the early release of her rapists. So, however, this same seems to have reinforced an egregious error on the judiciary's behalf. We know that in the infamous Bilkis Bano gang rape case, the people who were convicted of it, they have been released early as per the date that was actually stipulated for their release. So this definitely has brought out a rage amongst the people who were the supporters of the victim Bilkis Bano and she herself. So recently, the Supreme Court has issued a 2-page order wherein the review petition that had been filed by Bilkis Bano against the early release of the rapist has come up. So it was the Supreme Court that had heard the writ petition filed by Radhesham, who is better known as the Lala Vakil. Now, based on the acceptance of the writ petition and the subsequent direction for the Gujarat government to pay heed to Lala Vakil's remission and premature release, did the actual remission happen on 15th of August. So basically, it was Lala Vakil who had filed this writ petition against the order that was brought forward by the court earlier. Now, the review petition filed by Bilkis Bano was against the release order by the Supreme Court. Now, of course, after this early release that was brought, or the order of early release that was given by the Supreme Court, Bilkis Bano has filed a review petition against the very same order. Now, during the proceedings of Lala Vakil's remission petition, no chance had been given to Bilkis Bano to be heard in the court. Now, see, of course, when at all, if we are giving, or we are reducing the timeline of someone's conviction or someone's punishment, so obviously the victim should be given a chance to be heard once again to understand all the sides of the given case so that a very informed decision can be taken. But unfortunately, in this case, Bilkis Bano had not been given any such significant or substantial chance to be heard in the court. Hence, she requested to an open court hearing as per Order 47, Rule 3 of the Supreme Court rules. Here are some key factors that we need to look upon that have been completely overlooked in this case as far as follows. So firstly, writ petitions under Article 32 of the Constitution are not maintainable against the judicial orders, especially against orders issued by the High Courts. Whereas, on the contrary, in this case, the writ petition that was filed by Radhesham was taken into account. Secondly, the top court even ignored the 9-judge constitution bench binding decision in Naresh Sridhar Mirajkar, that is a case of 1966, and another 5-judge constitution bench in Triveni Bain case of 1989, which held that a judgment of a court can never be challenged in a writ petition under Article 32. So basically just giving the precedent of what we learned in the previous point. So even in the 1976 case of Madhya Pradesh versus Ratan Singh, it was decided that the state where the accused was convicted alone had the power to grant the remissions. So as we know that the power to remit, the power to pardon and everything, it lies with either the president or the governor. And ultimately this power of remission rests with the state itself. And thus the court may recommend so, or it may ponder upon the given factor, or it may also assist the state in the given case. But the power to ultimately decide upon the remission rests with only and only the state, which has completely been overlooked in this given case. Now, cryptic rejection of a compelling review between petition does injustice not only to the victim of unspeakable horrors, as in this case is Bilkis Bano, but also to the standing and prestige of the Supreme Court. It can only be hoped that the court will find some way to redress this injustice in the very coming time. Let's see, what do we have for news updates today? Firstly, Karnataka passes bill to increase quota for the SCs and STs. The Karnataka Assembly unanimously passed a bill enhancing reservation for the scheduled caste and scheduled tribes in the government educational institutions and state government services. The bill proposes to increase the quota for the scheduled caste from 15% to 17% and for scheduled tribes from 3% to 7%. Secondly, Indian origin scientist Parwinder Kaur named to STEM expert panel in Australia. STEM basically stands for Science, Technology, Engineering and Mathematics. So an Indian origin biotechnologist has been appointed to the Australian government's expert panel to boost diversity and increase women's participation in these STEM sectors. It has been noted, and it has also been observed in the recent times, that the participation of women That is the fields of science for S, T for we have technology, E for we have engineering, and M is mathematics. So the participation of women is low or is less as compared to the men in these areas, and that is why this is definitely going to work as a great symbolic, identity, as well as a step in the right direction, wherein a woman who we know as Parwinder Kaur has been named to this expert panel for STEM in Australia. So, Associate Professor Parwinder Kaur in the University of Western Australia Public Policy Institute Fellow, who hails from Nawanshahar of Punjab, will draw on years of experience as a scientist, academic, and immigrant to support diversity in Australia's STEM sectors. In 2019, she won the Microsoft's AI for Earth Award and was a finalist in Western Australia's Innovator of the Year 2022. Thirdly, world's highest paid female athletes 2022 list. So India's badminton star PV Sindhu is the only Indian player in the top 25 in the Forbes annual list of the highest paid female athletes in the world. The 2016 Rio Olympic silver medalist occupies the 12th spot in the list. Japanese tennis star Naomi Osaka tops the list. The list's top 10 includes Serena Williams, Emma Raducanu, Iga Swiatek, Venus Williams, Coco Gauff, and Jessica Pegula. For the record, Osaka and Serena are the only two women who are placed in the top 50 of Forbes' list of the world's highest paid athletes. Fourthly, Right to Repair Portal, National Consumer Helpline premises. Food and Consumer Affairs Minister Piyush Goyal launched a host of new initiatives, including the Right to Repair Portal and the NTH mobile app, and opened new premises of the National Consumer Helpline Center in the national capital. On the Right to Repair portal, manufacturers will share the manual of the product details with customers so that they can either repair any given thing by themselves or by third parties rather than depend on the original manufacturers alone. Initially, mobile phones, electronic gadgets, consumer durables, automobiles, and farming equipment will be covered under this scheme. Let's see what do we have for legal updates today. Firstly, the police should not act with presumption that every society or club will indulge in unlawful activities, says the Karnataka High Court. So the Karnataka High Court has said in the case of SRI Siragalli Lakshmidevi Recreation Club versus State of Karnataka that the police authorities should not act with the presumption that every society or association or club registered for the purpose of running a club will be indulging in unlawful activities. Secondly, can written statements of witnesses be considered to be statements duly recorded under Section 161 of the CrPC, says the Allahabad High Court, and it has answered so in the case of Faisal Ashraf versus State of UP and two others. So the Allahabad High Court has explained as to when the written statements of the witnesses could be considered to be statements duly recorded under Section 161 of the CrPC, that is examination of witness by police. The bench of Justice Saurabh Shamshiri observed that if the written statement has been submitted by the witness himself to the investigating officer and the investigating officer assures its genuineness and the same, if reduced in writing, shall be a statement duly recorded under Section 161 of the CrPC. This was all for today. We hope you liked the session. Thank you so much for staying tuned with LawSikho. If you wish to download the PDF of today's slides, you can join our Telegram channel. The link is there in the description box below, or you can also scan this QR code that you can see on your screens right now. Thank you so much.